Oh, SCOTUS fucked up. SCOTUS ain't perfect. And Trump's, Trump didn't appoint a bunch of libertarians to the Supreme Court, so we probably should have anticipated this. But yeah, the Supreme Court upheld some Biden era regulations on quote unquote ghost guns. Let's dig in. Shout out to SCOTUS blog and Amy Howe. Yeah, I felt like I don't know. I wanted to cover this because I'm a big gun guy, and I don't know, like it. It's kind of like I'm not like super outraged. I'm obviously against regulating ghost guns, but at the same time, it's like I'm pretty much against regulating all guns. But I didn't. The reason why I'm not like outraged is because I anticipated all this. Because of course, if we already regulate regular guns, of course we're going to regulate ghost guns and all 3D printed guns and kit guns and all this shit. So, you know, the Supreme Court on Wednesday upheld a Biden era rule regulating so-called ghost guns, untraceable weapons without serial numbers, assembled from components or kits that can be bought online. By a vote of 7-2, the justices held that the Gun Control Act of 1968 allows the Bureau of Alcohol, Tobacco, and Firearms and Explosives to regulate at least some ghost guns, although they left open the possibility that the rule might not apply in individual challenges to particular ghost guns. Justice Clarence Thomas dissented from the court's decision, complaining that it had agreed to rewrite statutory text. Justice Samuel Alito wrote his own dissent in which he contended that his colleagues had applied the wrong test to determine whether the ATF rule was valid. So again, Thomas and Alito, it doesn't even seem to be on general 2A principle. It seems to be mostly procedural why they dissented. The ATF adopted the rule in 2022 to address what it characterized as an exceptional increase in ghost guns. The Gun Control Act defines a firearm as quote any weapon which will or is designed to or may readily be converted to expel a projectile by the action of an explosive, including the frame or receiver of any such weapon. The ATF contended that the 2022 rule was consistent with the language of the law because it defines firearm to include products such as gun kits that can be converted into an operational gun or a functional frame, the basic structure of the gun, or a receiver, the part of the gun that houses the firing mechanism. The rule also clarifies that the term frame and receiver include partially complete or disassembled frames or receivers that can be readily completed or converted to work as a frame or receiver. So yeah, people thought they found a loophole, and SCOTUS is trying to close that loophole. But a group that included 2 individual gun owners and a gun rights advocacy group went to federal court in Texas to challenge the rule. A federal district judge in Fort Worth prohibited the agency from applying the rule anywhere in the United States. Although the conservative U.S. Court of Appeals for the Fifth Circuit largely upheld the decision, a divided Supreme Court put the district judge's order on hold, allowing the Biden administration to enforce the rule while it appealed. 4 justices, Clarence Thomas, Samuel Alito, Neil Gorsuch, and Brett Kavanaugh, indicated that they would have denied the government's request then. In a 24-page opinion by Gorsuch on Wednesday, the court upheld the rule. But anyway, yeah, see, Thomas and Alito both would have upheld the thing. Or at least that's how I'm reading that. I could be misreading it. I'm not a legal scholar. Congress enacted the Gun Control Act, Gorsuch explained, because it found that then current gun control measures allowed criminals to acquire largely untraceable guns too easily. The act requires manufacturers to put a serial number on guns and regulate commercial gun sales by, among other things, requiring gun manufacturers and dealers to conduct background checks and keep records of gun sales, which they already do. Advances in technology, Gorsuch noted, such as 3D printing and reinforced polymers, have changed the way in which guns are manufactured and sold. And in particular, companies are able to make and sell weapon part kits that individuals can assemble into functional firearms in their own homes. These kits are popular among hobbyists, Gorsuch wrote, but also among criminals because some manufacturers and sellers do not regard them as firearms subject to the Gun Control Act and therefore do not comply with the Act's requirements, leading to an explosion of crimes across the country. Is it really an explosion of crimes? I need to see some data on that because I mean the crime rate has gone up over the last 4 years or more, but I don't think that necessarily has anything to do with the readily accessible nature of ghost guns. Crime was declining in the United States for 40 straight years and then started to go up in the last 10. So Gorsuch emphasized that the challengers in this case were not asking the Supreme Court to decide whether the rule regulating ghost guns could be applied to specific kinds of ghost guns, that is, to, quote, particular weapon parts, kits, or unfinished frames or receivers. Instead, he stressed the challengers had asked the courts to hold that the rule cannot be applied to any ghost guns, but the Supreme Court decided to decline to do so. And I mean, I'm glad that they challenged it because, in principle, I agree. But that was a losing battle. The Supreme Court was never going to go for that. They were never going to completely say, "Well, sorry guys, but guns that if you just buy if you just buy a frame and a receiver and then 3D print, everything else for the gun. Sorry, but we our hands are tied. We can't regulate those." Of course they were. That's what the government does. It was never going to happen again. Like that's why I'm not like foaming at the mouth over this because this is all very predictable. First, Gorsuch explained. I keep going back and forth about whether I say Gorsuch or Gorsuch. First, Gorsuch explained the Gun Control Act allows the ATF to regulate weapons parts kits. The text of the act, he reasoned, imposed two criteria. First, that there must be a weapon, and the weapon must be able to expel a projectile by the action of an explosive, be designed to do so, or be susceptible of ready conversion to operate that way. In contrast with the Fifth Circuit, Gorsuch concluded that, quote, at least some kits will satisfy both of these requirements. He used, as an example, a kit named the Buy, Build, Shoot kit, a company called Polymer 80 that allows the buyer to quickly and easily build a Glock variant semi automatic pistol. An ordinary speaker might well describe the Buy, Build, Shoot kit as a weapon. Gorsuch posited, even if, quote, perhaps a half hour of work is required before anyone can fire a shot. He noted that even if sold, the kit comes with all the necessary components and its intended function as instruments of combat is obvious. Really, the kit's name should be Buy, Build, Shoot. Or really, the kit's name says it all. Buy, Build, Shoot. I'm silly today. I apologize. And the Buy, Build, Shoot kit also meets the second criterion because it can be readily converted into a firearm, for it requires no more time, effort, expertise, or specialized tools to complete than a starter gun, which is explicitly mentioned in the Gun Control Act. Gorsuch acknowledged that weapons parts kits vary wildly and may require more time, expertise, or specialized tools to finish. But the Supreme Court does not need to decide in the case when a kit may also be when a kit may be so incomplete or cumbersome to assemble that the ATF can no longer regulate it under the Gun Control Act, he determined. Gorsuch concluded, again, in contrast to the Fifth Circuit, that the Gun Control Act also allows the ATF to regulate partially finished frames and receivers. Gorsuch's opinion offered a picture of a complete frame of a Glock variant firearm, above a picture of a partially complete frame sold by Polymer 80, highlighting what he described as the main difference between the two: a pair of plastic tabs that the buyer would need to remove and then add pins. Here too, he observed that an ordinary speaker might well call the Polymer 80 product a firearm frame, even though a little work is required to complete. Just look again at the second photo, Gorsuch pleaded. What else would you call it? Gorsuch added that the ATF has, in the past, consistently interpreted the Gun Control Act to apply to at least some unfinished frames of receivers, including ones no more finished than Polymer 80's product. These contemporary and consistent views can provide evidence of the law's meaning, he noted. And indeed, he continued, the challenger, and indeed, he continued, the challengers say that they do not dispute the ATF's prior practice, a concession that all but gives the game away. Although the challengers contend that the new rule regulating ghost guns goes too far, he said. For our purposes, what matters is that even the plaintiffs do not really insist that the rule reaches only finished frames and receivers. So this whole thing is like it's a little murky. It's not really murky. It's actually pretty cut and dry, because if we're taking Gorsuch at his word, then the complainants even admitted that, like, yeah, the ATF's rule probably does cover this. As with weapon parts kits, Gorsuch concluded that the court's reasoning has its limits. Some products, he wrote, may be so far from a finished frame or receiver that they cannot fairly be described using those terms. But this case, he wrote, requires us to explore none of that. No, again, because the product they're specifically talking about is a type of weapon that all you got to do is remove two pieces of plastic and insert a pin. You know what I mean? So the gun is basically 99% complete. Gorsuch rejected the challengers' request to rule in their favor based on either the rule of lenity, I think that's how you pronounce that, the idea that when a criminal law is ambiguous, it should be applied in a way that is most favorable to the defendant, or the doctrine of constitutional avoidance, which instructs court to avoid ruling on constitutional issues unless it is absolutely necessary. Gorsuch, perhaps the court's strongest advocate for the rule of lenity, countered that neither lenity nor avoidance has any role to play where text, context, and structure decide the case. The Gun Control Act embraces, Gorsuch concluded, and thus permits ATF to regulate some weapons, parts kits, and unfinished frames or receivers, including those we have discussed. This is a fucking long article. But we're almost done. It's a lot of legalese. Justice Brett Kavanaugh wrote a two-page concurring opinion in which he observed that the line between ghost guns, to which the ATF's rule and therefore the requirements of the Gun Control Act, such as background checks, licensing, and serial numbers, does or does not apply, is not entirely clear. Individuals can face criminal liability for violating most of these requirements only if the government can show that they knew their conduct was illegal, Kavanaugh noted, a high bar. But someone who violates the background check requirement, Kavanaugh continued, is subject to a lower standard and can face criminal liability even if they were aware that they were violating the law. Kavanaugh suggested that the federal government would avoid the potential fairness problems that could arise in such a situation by adhering to its oral argument representation that it would likely decline to bring charges in those circumstances. So, yeah. Justice Sonia Sotomayor was less concerned about the issue that Kavanaugh raised, deeming them unfounded in her own two-page concurring opinion. Firearms manufacturers and dealers have long complied with the Gun Control Act's requirements, she wrote, and ATF's rule should come as no surprise. I actually agree with Sotomayor there. This should not surprise anyone that this was going to happen. But to the extent that the manufacturers aren't sure about whether the rule applies to their products, she concluded, the ATF encourages them to seek guidance from the agency. Manufacturers have long taken advantage of that process, she added, and a failure to do so might suggest willfulness on their part. She's essentially saying that gun manufacturers sometimes, some gun manufacturers anyway, are sometimes in like deliberately selling these kits and kind of implying that it's like, hey, bro, this is totally legal to buy this. It's like, yeah, this isn't a fully functioning firearm, so this totally doesn't require background checks or anything like that. So go ahead and buy it. Thomas would have held that the ATF rule was not authorized by the Gun Control Act. In his view, the, quote, ordinary meaning of frame or receiver does not include unfinished frames or receivers. Similarly, although An object that may readily be converted into a gun qualifies as a firearm if that object is already a weapon. An object that is not already a weapon does not. And here he said the quote ordinary meaning of weapon does not include weapons parts kits, which are unfinished and inoperable. But at the very least, Thomas continued, the Gun Control Act is ambiguous, which would call for the application of the rule of lenity. Yeah, See, this is the thing that I have an issue with a lot of law. I don't like ambiguous laws. I think laws should be very specific. If something is illegal, it should be laid out in plain, simple English that anyone can understand. This is one of the big problems with legalese is it's too murky. It leaves situations like this up in the air where it's all like, well, this isn't a complete firearm, so this doesn't count. Congress, Thomas concluded, could have authorized the ATF to regulate any part of a firearm or any object readily convertible into one, but it did not. I would adhere to the words Congress has enacted. Alito disagreed with the majority decision to use the same test that courts use when reviewing challenges to the constitutionality of laws as they are written, without regard to particular facts. The challengers in this case, he contended, had not agreed that such a test should apply, and the federal government gave it only cursory treatment in its brief. Alito also questioned whether the test, known as the Salerno test, should apply. In the court's decision last July, sending First Amendment challenges to Florida and Texas laws regulating large internet platforms back to the lower courts for another look, Alito explained he wrote that one important reason to use the Salerno test is quote quote is respect for the lawmaking authority of the legislative body that enact the laws in question, but that quote threat to legislative authority is not present when the regulation is challenged, he noted. He therefore would have either instructed the litigants in this case to brief this issue or send the case back to a lower court for it to consider. So yeah, see, okay, Thomas's opinion is a little bit more, straightforward. A little bit more, no, these weapons are incomplete, thus they don't count. Whereas Alito was a bit more about like procedural. Like, is this really the procedure for this particular case? Does this case need to come up this high? Can't this be handled by a lower court? Yeah, no, this was a bit of a long one, bit wordy. But yeah, so again, I decided to point this out because the SCOTUS kind of, I mean, again, this doesn't shock anybody. It shouldn't shock you. It doesn't shock me. We're not allowed to have unregulated firearms as much as we wish we could have unregulated firearms. I agree. We shouldn't have regulated firearms. We should be able to buy almost practically any weapon we can afford. That was the intent of the Second Amendment when it was written. So, yeah, SCOTUS isn't perfect. Never has been. This is a bad call by the court, but once again, Clarence Thomas proves to be the real G on the court, which is why that meme was so popular. I wish I could pull it up. I could, I guess, but I'm not going to bother searching for it. But basically, it was raging trans soy jack screaming, Republicans are all a bunch of racists, and then below it says our ideal Supreme Court, and it was 9 Clarence Thomases. And I was just like, yeah, I could live with that. Yeah, we're real racist. We would love 9 Clarence Thomases as our Supreme Court justices. But yeah, no, let me know what you think below. Did the court make the right call? Did they make the bad call? Am I stupid and I shouldn't cover this type of stuff? Just let me know. Feel free to pillory me in the comment section. It's good for the algorithm. And also smash the like button. And also follow me on X and sub to all of my other channels. And you know the drill at this point. So go get a ghost bone and throw it at me.